If you're a firearms instructor, or you're about to sign up for a concealed carry class, there's a practical checklist you need to understand right now, because a growing legal trend means your training records, or the instructor's records for your class, could end up being read out loud in a courtroom someday, and neither side is currently well prepared for that possibility. Instructors across the country are increasingly facing lawsuits and subpoenas tied to what a former student did months or years after training concluded, and students are largely unaware that the quality and documentation of the training they receive could matter enormously if something ever goes wrong. Most guidance on this topic stops at explaining that the trend exists without ever getting specific about what an instructor should actually change about how they run a class tomorrow morning, or what a student should actually ask before handing over their money. I'm going to walk you through exactly what instructors should be doing differently right now, what students should actually look for before choosing a training program, and how this entire legal landscape is reshaping the practical, day-to-day reality of firearms instruction. Before we get into it, if you want practical, actionable guidance instead of just an explanation of a legal trend, subscribe and turn on notifications right now. This is exactly the kind of situation where understanding the trend matters less than knowing specifically what to do about it, whether you're standing in front of a classroom or sitting in one, and the instructors and students who act on specifics now will be in a completely different position than the ones who wait until it's already a problem. Let's get into exactly what you need to know. Here is the core legal reality driving everything in this breakdown. When a former student is involved in a shooting incident, whether that's a self-defense situation, an accidental discharge, or a case where someone froze during a genuine emergency, attorneys representing an injured party increasingly subpoena the instructor's complete training records for that specific student. That means lesson plans, documented qualification standards, any notes about the student's actual performance, and the instructor's own certifications all become potential evidence. If you're an instructor and you can't produce clear, specific documentation showing what you actually taught, how you evaluated the student, and why you determined they were ready to carry, you are in a significantly weaker legal position than an instructor who can. The first segment is what instructors should actually be doing differently, starting with documentation, because this is the single most important practical change available to you right now. Every class should have a detailed written lesson plan, not just a general outline in your head, covering exactly what safety principles, marksmanship fundamentals, and legal knowledge you taught in that specific session. For each student, maintain individual notes on their actual performance during training, not just a pass or fail checkbox, but specific observations. Did they demonstrate consistent safe muzzle discipline? Did they show sound judgment during scenario-based exercises? Were there any moments of hesitation or concerning behavior you addressed during the class? If you have genuine concerns about a specific student's readiness, document those concerns in writing at the time, even if you ultimately decide to certify them anyway, because a contemporaneous written note carries far more legal weight than a memory reconstructed years later during a deposition. Consider this concretely. If a former student is involved in an incident 2 years after taking your class, and an attorney asks you under oath whether you had any concerns about that student's judgment during training, your answer is dramatically stronger and dramatically more credible to a jury if you can produce a written note from that actual day rather than relying entirely on your memory of one student among the thousands you may have taught since. Set up a simple system now, a standardized evaluation sheet you fill out for every single student, every single class, so that documentation becomes routine rather than something you only think about after you're already worried about a specific situation. The second segment is what to do about your own qualification standards, because vague or inconsistent standards are exactly what plaintiffs' attorneys look for when building a negligent training case. Have a clear, written policy about what specifically disqualifies a student from certification, inability to demonstrate safe handling after a reasonable number of attempts, failure to show basic understanding of use of force law, visible signs of impairment or instability during class, and apply that policy consistently across every student you teach. An instructor who can show a jury a clear, written standard that was applied consistently is in a dramatically stronger position than one who made case-by-case judgment calls with no documented criteria behind them, even if both instructors made exactly the same underlying decisions in practice. The third segment is the insurance question, because this is a practical financial protection that too many instructors either don't have or don't fully understand the scope of. General liability insurance covering a range or facility is not automatically the same as professional liability coverage, specifically protecting an individual instructor against claims related to their teaching judgment and training adequacy. If you're currently teaching without confirming you have the second, more specific kind of coverage, that's worth addressing immediately, not after you've already been named in a lawsuit. Several firearms industry organizations now offer instructor-specific liability coverage designed exactly for this kind of exposure, and the cost of that coverage is genuinely small compared to the potential cost of defending even a single lawsuit without it. The fourth segment is what students should actually be looking for before choosing a training program, because this legal trend cuts both ways, and a program with weak documentation and inconsistent standards isn't just a liability risk for the instructor, it's a sign of genuinely inadequate preparation for you as the student. Ask a prospective instructor directly about their qualification standards, what specifically would cause them to decline to certify a student, and whether they document individual student performance beyond a simple pass or fail. An instructor who can answer these questions clearly and specifically is very likely providing more thorough, more genuinely useful training than one who seems annoyed by the question or gives a vague answer, because the same documentation discipline that protects an instructor legally also reflects genuine pedagogical care about whether their students actually leave prepared. The fifth segment is what students should understand about their own responsibility in this picture, because training adequacy is only half of what actually determines outcomes. No amount of documentation or instructor liability protects you personally if you fail to actually absorb and practice what you were taught. If you complete a concealed carry class and never practice again, never revisit the legal principles you learned, and never honestly evaluate your own comfort level with the responsibility you're taking on, the quality of your original training becomes almost irrelevant to how you'll actually perform in a genuine emergency years later. Treating a single class as a permanent credential rather than a starting point is one of the most common and most dangerous misunderstandings among concealed carry holders generally, entirely separate from whatever legal trend is unfolding around instructor liability. The sixth segment is what training organizations, as opposed to individual freelance instructors, should be doing structurally, because the same legal exposure applies at an organizational level too. Standardized curricula across every instructor working under an organization's name, regular auditing of individual instructors' documentation practices, and organization-wide liability coverage that doesn't leave individual instructors personally exposed are all becoming increasingly standard practice among larger, more established training providers, specifically in response to this legal trend. If you're choosing between a large established training organization and an independent instructor working solo, it's worth understanding that the larger organization has likely already invested more heavily in exactly the kind of documentation and insurance infrastructure this trend is pushing the entire industry toward. Though that doesn't automatically mean the actual instruction quality is better, since a careful independent instructor with strong personal documentation practices can absolutely match or exceed what a larger organization provides. The seventh segment is the honest, harder question worth sitting with if you're an instructor, separate from the purely defensive legal protection angle. Beyond simply protecting yourself from liability, this entire trend is worth treating as a genuine prompt to examine your own teaching standards honestly. If you've been certifying students who technically meet a bare state minimum but whose judgment or safety habits gave you real pause, the legal exposure this trend creates is, in a sense, forcing a conversation the industry arguably should have been having on its own merits, regardless of liability concerns. Raising your own personal bar, being willing to fail or decline students who aren't genuinely ready, protects you legally, but it also, more fundamentally, protects the actual safety of your students and the people around them, which is presumably why you became an instructor in the first place. Let's step back and name what actually matters most out of everything covered here. Whether you're teaching or learning, the practical answer to this entire legal trend is the same: more documentation, clearer standards, and more honest evaluation of actual readiness, rather than simply checking required boxes. Instructors who build these practices into their normal teaching routine now, before they're ever named in a lawsuit, are protecting themselves far more effectively than any instructor scrambling to reconstruct documentation after the fact ever could. Students who ask pointed questions about an instructor's standards and documentation practices before signing up are getting genuinely better information about training quality than students who simply choose based on price or convenience. It's worth acknowledging that none of this guidance requires waiting for a specific new law or a landmark court ruling to start implementing. Every practice covered in this breakdown: better documentation, clearer written standards, proper insurance coverage, more pointed questions from prospective students, can be adopted starting today, entirely independent of how this broader legal trend eventually resolves itself through legislation or further litigation. That's genuinely good news if you're feeling overwhelmed by the idea of an entire legal landscape shifting underneath an industry you're part of, because the actual response doesn't require predicting exactly how courts will rule in future cases. It just requires building better habits now that would serve you well regardless of which direction this trend ultimately takes. If you take one thing away from this breakdown, let it be this: a legal trend like this one rewards preparation and honest, consistent practice long before it ever punishes anyone. And the instructors and students who treat that preparation seriously now are the ones who'll be least affected whenever this trend eventually produces the kind of headline-grabbing case that finally gets everyone else's attention. Start with the documentation habit if you're an instructor, and start with the pointed questions if you're a student, because both of those changes cost you almost nothing today and could matter enormously down the road. If this helped you understand what to actually do differently, share it with an instructor or a fellow student who hasn't thought through this side of firearms training. Subscribe so you catch the next development in this space, and I will see you in the next one.